Good evening, everyone. Welcome to White Collar Supports Group's Tuesday White Collar Speaker Series. Tonight, our special guest speaker is Alex Little, a criminal defense attorney from Nashville, Tennessee. More about Alex in a minute, but we are very excited to have him here. This event is brought to you by the White Collar Support Group. We are the world's first support group dedicated to people navigating the white collar justice system and their families. We meet every Monday on Zoom at 7 p.m. Eastern and 4 p.m. Pacific. We have a lot of other events as well and initiatives. More information about that can be found on our website at prisonist.org. That's prisonist like feminist.org. You can also find more information about our upcoming conference. Our annual conference is now slated for October 10th at it's a Saturday morning at 9 a.m. Eastern. So it's a little early for you folks out on the West, but that's on 1010. You can find out more information about that on our website or on our conference website, whitecollarconference.com. And you get more information about our federal expungement initiative, which we'll be talking about in Manhattan on Thursday at a criminal justice gathering that a bunch of us are going to be at. And more information about that is at federalexpungement.org. Just have a few things to talk about. Upcoming speakers. On May 12th, our speaker is going to be Tom Harden, known in the insider trading world as Tipper X. He was the primary informant in Operation Perfect Hedge during all the insider trading prosecutions, and his new book, Wired on Wall Street, is out, and Tom is on an extensive book tour right now, and he's going to bless us with speaking to us on May 12th. PG Sittenfeld is going to be our speaker on June 2nd. PG was a council member of the City of Cincinnati City Council, got indicted, has an amazing story, what looks to be an incredible turnaround at the United States Supreme Court, which has now sent the case back down. And I would imagine that the case is going to be dismissed in its entirety shortly. On July 14th, we have Karen Kelly. Karen is a partner at Kostelanetz in Washington, D.C., and she used to be the head of the Department of Justice's tax division. And she's going to be talking to us about criminal tax implications for white collar crime, what to do, what not to do, and hopefully how to stay out of trouble. Let's see, that leads us to Alex Little, our speaker tonight. I'm gonna read what I put in the emails and online about Alex, and then I'll just say a couple of words, and then we'll hand it over to Alex. Alex Little is the founder and managing partner of Litson PLLC, a boutique federal litigation and white-collar criminal defense firm based in Nashville that operates nationwide. Before representing clients in the federal system, he sat on the other side of it, serving as an assistant U.S. attorney prosecuting complex federal cases. His path to the courtroom was anything but traditional. He began his career in international diplomacy with the Carter Center before pivoting to work in intelligence at the CIA before law school. Today, Alex leads a team that includes 4 former federal prosecutors and focuses exclusively on federal criminal defense, clemency and pardons, and high-stakes civil litigation. He's the author of the forthcoming book, Spies, Saints, and Stingers, which introduces his Diagnose, Empathize, Preach framework for navigating impossible problems. Among other things, I'll tell you that Alex is currently probably and has been the attorney for several people in our support group and some of our closest friends and speakers. He came to our attention. I gave him a call. He was such a gentleman, and I learned about him very, very quickly that in many respects he's a Renaissance man, and he has all kinds of interests that I assume he's going to talk to us about tonight. Almost all of it for the benefit of society. So I think he's terrific. So Alex, why don't you take it away?
Great, Jeff. That's really kind. Thank you. I'm really happy to be here and meet many of you for the first time. I have known about this group for a few years when I was lucky enough to have clients who participated in it and really benefited greatly from everything that you all do. It's an incredible project that you have and helping people every day and the families going through this really difficult process that is the criminal justice system. Um, Today, I want to do a talk. Many of you, it's sort of difficult when you're talking to people in the system to come up with something new that you haven't heard. What's sort of unusual about, the next sentencing issue or this, particular Fourth Amendment problem that comes up, or on the flip side, dealing with issues about reentry. So instead, I had an issue a few years ago when we started this firm. I had to kind of somebody asked, why do you think you're successful at what you do? You've had numerous cases where your clients have gotten in situations that have been a much better result than they should expect, and things that weren't sort of expected to happen. What do you think made you and your firm sort of well positioned to do that? And so I thought about that, and it sort of took me some time to think about what we were doing that was different than maybe other criminal defense attorneys. Not that we're particularly special, but that we do have a different approach to it. And I think part of that came from my background. And the very brief bio of that is I started my career not in law. I worked with former President Jimmy Carter doing conflict resolution in Africa. So I thought that was going to be what I did for my life, go be an international diplomat, run around and try to solve these civil wars. And so I spent the first weekend after graduation in Nairobi, Kenya, with the president of that time Sudan, the president of Uganda, and the president of Kenya, talking about the war between Sudan and Uganda, the proxy war. That, after many iterations, eventually led me to the International Criminal Court with a stint at the CIA in between. And then at the International Criminal Court, I met a former federal prosecutor who I just thought was brilliant. And the work that she described doing was really, really interesting to me. And that sort of pushed me on a path to be sort of a real stand-up in courtroom lawyer that I hadn't ever thought about, even when I was, in law school or applying to law school. And so, in retrospect, looking back on those experiences, I realized that there was quite a bit that I'd learned that was really different than I think most lawyers approach the problems we're facing. And so, I've set about to kind of document that and spend some time putting it into a book. The book is not called The Knock, but I wanted to sort of put the framework that I've worked on in how we think about cases into a very concrete context that all of you will understand. And so I wanted to talk about what happens in that first 72 hours at the early stages of a case, an investigation, when a target is aware now they're being investigated. And how can you maybe look at that from a perspective that's a little bit different and apply the frameworks that I think we think about at the firm to the situation. So that's what I'm going to talk about today is what happens when you get that knock from the FBI. I mean, the FBI doesn't knock. It's one of the jokes we have. They just come on in. But it could also be the first time you get the CID, you get the subpoena, you hear from a friend that the FBI has shown up and they've left a car and they want to talk. Those first 72 hours are critical. The case is in motion. I think a lot of people forget about that. The day that you learn it, and so many of you have lived this, the day that you learn about your case, it could have been going on for years. In some cases, I've had clients, it's been going on for as long as 8 years before the target sort of is aware that this is upon them. And so you're not trying that first 72 windows to catch up. What you're really trying to do is not make it worse. That's your first opportunity to really stop the bleeding, to stop the progress further down the criminal justice system. I tell clients I have this graph, and it's exponential. It's a graph of exponential growth. On the left side, where you're down towards zero, that's what happens before there's an investigation. And on the right side is when you've lost your post-collateral attack and you're trying to get exonerated. Every step down the timeline makes it exponentially more difficult for you to get a good result in the criminal justice system. That's just how it's made. And so the earlier you could have an intervention and do good work, the better your chances are. And so this is kind of where I've thought about this hopefully a little bit differently. And it's that I thought about my work as a spy or as an analyst, taking what the spies brought in and made sense of it. My time working with President Carter, who really was just a one of one human being, but a particularly good diplomat. at being able to solve really difficult conflicts. And then as a trial courtroom lawyer now for 20 years. And each of those careers, I think, brought a particular skill set that turned out to be really important to do what I do now. And it started with the CIA in the sense that intelligence work is really about seeing what's happening. It's diagnosing the situation with real discipline, almost as if you're a physician trying to hone in on the actual physical symptoms, the actual problems, and not just the manifestation of those. And to do that, there's so many things that we get in our own way about the information that we need to make decisions. And if we don't have good information, we can't really go further sort of up the chain to solve the problem. But really having good information and diagnosing the problem you're in, which in the first 72 hours is really difficult. I think people get overwhelmed by the fact that they're under investigation. There've been armed, agents at their house. And so diagnosing the situation you're in is incredibly difficult. But you then have to build on top of that really this diplomatic step of understanding the people who are now going to decide your fate, the prosecutors, the agents, the judges, the other lawyers, and understand what motivates them, what constrains them, what are the goals and objectives they have. Because if you're going to get them to do something you want, and in the criminal justice system, very rarely can you unilaterally sort of just assert your will. You need the other side to compromise or to do something you're hoping that they will do. And so you can't do that unless you really understand the other side and empathize. And then third, once you've got those two pieces of the pyramid beneath you, you can actually start to advocate towards the goal that you want, whether it's a dismissal, a non-prosecution agreement, and information without jail time. Have to build that. You can only build that at the top of the pyramid when you have really good information and when you know the other people who are involved in making that decision, you know how they're going to behave or how they might behave in certain circumstances. And so I'll start with really the first stage of diagnosis. Everybody says this, don't talk, right? But silence is a really concerted strategy at the beginning. You can't have any calls, no clarifying emails, no social media. You can't talk with anybody about the facts. Because if you're trying to understand what's happening, if you're adding data, you're adding information to the situation at the very early stages, you're just going to make it worse. Not just because that could be used against you, but because you need to be listening. You cannot listen and understand what's happening if you're having to talk and talk and talk about what's going on. And so silence is a strategy that's really necessary to understand. And then in those first few moments, really in the first part of those first few hours, you have to do what I call the magic wand test. You have to ask yourself, or if you're a lawyer in my place, you have to ask your client, what does winning actually look like? I want to beat the case. I want to clear my name. I want this to go away is almost always what we hear, those sort of things. But they're not specific. They're not real goals that we can look at in the information architecture and say, okay, that's a goal that we can achieve and identify clearly. And so a client says, I want to clear my name. What does that mean to you? If you really had the magic wand, what can you specifically do with that magic wand from the moment these folks have shown up to change your situation? And so whether it's a declination letter or we want the company to survive, and the very first kind of step when you're gathering this information about what's happening, you need to know and kind of put an anchor down that no matter what everybody else does, here's where I want to go. You need that direction. You also, at the beginning, in the first really 24 hours, you have to do what I call swallow the ocean. A good defense attorney at the beginning of the case is just a complete vacuum, just gathering up every piece of information from every possible source. You're interviewing the client, you're talking to anybody who is there to search warrant, you're looking on the web, you're talking to other people in the company if it's a company. You are desperate for as much information. You're gathering emails, you're gathering as much as you can. And you're doing it without trying to immediately make a judgment about what's happening. The theories contaminate memory. You don't want to say, oh, this is what's happening. Now give me the evidence. This is what's happening. You want to just swallow the ocean, because if you have an interpretation of what's happening, it's wrong. Everything you do from that point forward is corrupted. And I said, premature interpretation is how people just, you script your own indictment. If you say, this is what's happened and I'm going to prove it, or this is what the evidence is going to show to your lawyer, and if you as a lawyer believe that, you're doing yourself a massive, massive disservice. In the early stages, you have to just take it all in. And this is I love this story, and it's a terrible graphic of it, but I couldn't find the actual photograph. Um, in World War II, and many of you have heard this before, there were planes that would come back from bombing runs over the South Pacific. And they did a study um, that found where all the holes in the planes were, different parts of the wing, different parts of the fuselage. And the initial recommendation from the Air Force was, well, we need to put extra steel on the places where the holes are, because that's where all these ships are getting they're getting just, they're getting shot. We need to protect those areas. And there was a mathematician named Abraham Wald, and he said, no, that's a completely wrong way of looking at it. What you're missing is the aircraft that don't make it back to land. And they don't make it back because they were destroyed with the catastrophic hits. The planes that land with the bullet holes are landing because those bullet holes weren't catastrophic. They weren't critical. You never saw planes land that had bullet holes in the back tail of the plane. You never saw bullet holes on the cockpit of the plane because those planes don't make it home. And so, particularly in the first 72 hours, because it's hard to be silent, and I don't just mean silent with the FBI, but I mean just silent as someone enduring this. And you want that, you're sort of engaged in this chaotic movement of what happens in the early stages of a case. You don't think about that dog, the proverbial dog that doesn't bark. And so much of what you can learn in the early stages of a case is, what's the government not doing? Who didn't get a target letter? Why did the government not execute a search warrant at this location? They executed a search warrant, but they didn't look for this thing. They looked for this other thing. And there's all these missing pieces that contain really important data. And so if you're focused on the things that happen and not really sort of soaking in the things that don't happen, you're only getting half the picture. And when you do that, the sort of double problem of that is you don't have the right questions to then ask about what's really going on because you're not seeing the complete picture. Um, so at that stage, before I move sort of the second tier of this process, at the first stage of diagnosing your problem, you need to do it without bias. You need to be very objective about the situation you find yourself in, both as a defense lawyer, how difficult is the situation my client finds himself in, as the potential target, really, what am I facing, and what sort of outcomes are available here. If you do that with bias, if you say, I wish it's this or I want it to be that, you've really sort of blown the first step, which is understanding what's happening. And understand what's happening is critical to be able to affect what's happening and change what's happening. So once you have some sense, and the reason I sort of use the spies word in the book and talk about that as sort of section one, this diagnosis discipline, is because we have whole sections of our government. The CIA is a massive intelligence service. And most of what it does is produce some sheets of paper and reports and maybe some presentations for policymakers to help them make a decision. And there's some operational pieces to the CIA, but 80%, 90% of its staff is built around just trying to understand what's happening in the world. It is essentially a BBC or a New York Times for a very small set of people. I don't think that federal agencies that are investigating crimes operate that same way. The FBI doesn't see itself as an information gathering organization. The DEA doesn't see itself as an information gathering organization, which is a huge benefit if you're a defense lawyer and you understand that that is a critical part of the job. Because when the FBI or the ATF or the DEA or Secret Service are investigating a case, and they don't pay attention to that just core information gathering role because they want to move on ahead to prosecute or to get justice, they're probably going to leave things behind. They're not going to have the whole picture. And so if you as a defense attorney can really own the information gathering and know more than everybody else, the prosecutors, the agents, the other cooperating witnesses perhaps, or the co-defendants, you put your client in a much better position. Um, but then you get to the step of here's what the situation is. What do I do about it? How do I deal with the other parties, whether it's my client or if you're the target? How do I deal with my lawyer? How do I deal with the prosecutors? How do I deal with the judges and the agents? And you have to enter this stage of empathizing with these people who you often think have really done you harm. And in some cases, they really have done massive harm. Um, but you have to empathize, not to try to, feel sorry for them or to somehow give them the benefit of the doubt. You have to empathize objectively because you need to know what you're actually dealing with. Because if you have a slanted view of that, you can't advocate and find the answers, the types of arguments that might lead to a dismissal. And the first step of all of this, and it's something that I learned really early working in the kind of world of conflict resolution with somebody like President Carter, is that nobody is irrational. Nobody is the bad guy in their story. Everyone, including that just terrible agent you're dealing with or that prosecutor you think is completely unreasonable, believes that they are unreasonable or believes that they have um, bad motives. And so it's really the first step of doing the objective empathy that you're going to need to do to get to a solution or to find a way out of this problem. You have to accept that everybody's behavior is a function of the things that affect them, but inside their own mind, they're navigating those variables in a way that they find rational. So, for example, whether it's incentives, audience, constraints, fear, you have to map that on the people that you're dealing with. And I would say a huge part of the conversations that I have in the early stages of a case, and it just ramps up from there with the client, that they have questions about is about understanding the behavior of the other side. Why won't the government offer this plea? Why won't they do this? Why do they think this thing? Why is the judge that doing this? Is he or she gonna give me this sentence? Um, all the questions that the client often wants to know, maybe a day after or 2 days after is why is this happening? And that means oftentimes, why is this person doing that? And so a huge part of our work as defense lawyers, we don't think about it this way, is really trying to map and understand the behavior of the folks around us. And so with a prosecutor, that might be something like a conviction rate. They care about their trial record. They want to be a supervisor. They want a press release. I mean, I could go on for probably 2 hours talking about the things that motivate prosecutors. They also probably think that they're doing, God's work and they're true believers in the criminal justice system. But if you don't understand who you're dealing with and what motivates them, that it's going to be really difficult trying to negotiate a plea or, God forbid, get them to dismiss a case. Because unless you know what you're optimizing for, unless you know what you're trying to do to move the other side, you're negotiating with a ghost. You have to put bones, you have to put muscle on that person on the other side to be able to get a party on the other side that you can do business with. That's also the jurors. I think a lot of times, at the end of the day, if you take this to the full process, you've got 12 of those people who have their own incentives, constraints, fears, and things that are motivating them, such as I just want to go home, or gosh, I want to, do what's important for my community. And you have to sort of take that 12 layers of motives, constraints, behaviors, and think about that the whole way through trial, which is a really complex process, obviously. But if you don't do that, then you're just sort of, having play cartoon characters, and you're not going to even think about this in a way that's moving the ball. Um, I'll end this point with the idea that behavior that may look crazy to you always has some sort of internal math that justifies it. Nobody is out there generally, unless they're truly mentally ill, acting without some motivation. So you can understand that. Um, and you then have to recognize one of the first things you recognize when you start to understand that is that the people who you're trying to understand, well, they have their own power structure they're dealing with, because they're also dealing with other people. The line supervisor is dealing with the line AUSA is dealing with the supervisor, the agent's dealing with their partner or their boss. Sometimes you have main justice, you have disputes between state prosecutors and federal prosecutors. And depending on where you are, it's very, very rare that the real influences that an individual prosecutor or case agent are feeling are reflected on an org chart. I have this sort of on the slide. I say, you got to figure out who fears who or who needs something from somebody else in the first couple of days. And that's probably aggressive, but it's really important early on to understand who actually is going to be making the decisions that's going to affect me if I'm the target or my client if I'm the lawyer. Who are these people and what do they care about? And who are the people that they care about? When we do pardon and clemency work, a huge part of what we do is think about not just what the president's going to do, but who's going to be advising the president. What do they care about? And what people do they care about? What issues do they care about? And so mapping sort of the real power structure in the middle of an investigation or a criminal case is absolutely critical to being able to navigate it in a way that's going to help the client. So I say that when you do this, you need to borrow the eyes of these individuals and not their blindfold. You have to be able to see the case the way the government sees it without believing it. I have sort of two examples here that contrast a little bit. White collar cases, my client says it's a lawful consulting arrangement, or it's just an accounting mistake, or a colleague asked for a favor, this is not a bribe or kickback. That's often an honest assertion of what this person believes, but we need to understand how the government sees it, and we don't have to accept that they're correct. But if we can't see it through the government's eyes, in this sort of middle step, we're going to have a very, very difficult time changing a juror's mind or building a defense that is going to actually prevent that story from being accepted as true. When you do this with the other side and you start to think about their constraints, you start to think about what motivates an agent, what motivates a prosecutor, a witness, why are they saying these things? What's the judge going to do about this motion? It's a high profile case. They may not want to grant this and dismiss the case just because of the press. That's all really critical. But you also have to apply this sort of rubric to yourself at this stage. You have to really be objective about what you as the target care about, and you as the lawyer have to facilitate that discussion really early with the client. What are the constraints that you have? Some folks say, I just don't want to go to jail, or I just want to fight to the end. Well, if your constraint is I want to fight to the end, but you don't have any money and you want 14 expert witnesses, something has to give, right? You can't do that. There are some strategies about how you might approach a trial, but you can't do that because your reputation is terrible or the type of case makes it really difficult to assert those sorts of arguments. So you have to understand what constrains you: family, professional licenses, things like sobriety, your reputation, the corporate issues that affect you as an individual before you can navigate to the next stage, which is really making that pitch and advocating for a particular solution. Sorry about that. So once you've set up, you have this foundation of knowledge where you really are seeing the situation clearly. You have used sort of diagnostic discipline to understand the situation your client faces or the situation you as the target are in. You then have spent time really mapping the terrain of the other individuals who are going to make decision. You understand their constraints. You understand what generally you think they care about and how they might view the situation differently, very differently from you. You then have to apply judgment. And when you apply judgment, you have to choose one story. It is generally just not going to work if you say to a prosecutor, my client's guilty, my client's not guilty. I'm not sure why. I've got about 13 stories. Let me just run them at you and see if you like that. You can't come with 5 defenses. You can't do that to a jury. You really can't do that to a judge. You certainly can't do that to an AUSA at a proffer or reverse proffer trying to get him to dismiss a case. You've got to have a single story, and it's got to fit the facts, the client's character. There's a few reasons for that. The most, I think, obvious is multiple theories, multiple attempts. They signal uncertainty. If the prosecutor in these first 72 hours, the first weeks, think that you're uncertain about your client's innocence, that invites an indictment. That is blood in the water. And so your certainty around one story, my client is absolutely not guilty because of this, or you don't have a case because of this. There's no crime here because of this legal issue. If you don't focus on one thing, you invite the government to convince themselves that you're just sort of flailing. You don't want to be flailing. Within those first 72 hours, if you have the ability to ascertain the facts that quickly, if you can know the lay of the land of who you're dealing with, you should be able to at least have a rough draft of what your core defense theory is. And if you can do that, if you can do that quickly, you are then on the front foot and you are in a position to be able to aggressively make that argument over and over and over again. When you have this opportunity, whether it's in an email, in a presentation, or at the early stages to get a case dismissed or a case not brought before get declined, even if you have all these rational reasons, which you have to have, you've got to lead with feelings. Prosecutors are people before they're lawyers. And I think nobody's going to be surprised that people in the criminal justice system are making decisions emotionally. The OJ case, they probably didn't have the best evidence overall. If you kind of looked at the evidence that prosecutors had, they had a whole bunch of pieces that might have fit to the story that he had committed that murder. The defense won on the story. They had, a pithy line. If it doesn't fit, you must acquit. They had the emotional sort of arc of making the jury angry at the defense behavior and the things they had done. It's not just the jury that reacts that way. It's the prosecutors, it's the judges, it's the supervisors. If you build a narrative up the line that allows the AUSA to take this story, look, I think what happened is we had an agent who really they were an eager young agent. They thought this was a crime. They didn't do any of the work to figure it out. And they just made some really bad assumptions. That's a story that a prosecutor can tell their boss that they can understand and has some real emotional appeal. Everybody understands the cage agent was just trying hard and missed it. So when you're thinking about how to convey this story and how to articulate why they should dismiss the case, not indict, give you a great deal, you have to lead with emotion, which I think is somewhat ironic because we start with facts and we end with emotion. But we have to know the emotional hook for it to hit. Whether, if you watch a movie, you read a book, you even listen to a song, the emotional punch isn't as effective if it's disconnected from the surrounding factual circumstances. And the best emotional punches and the best sort of stories are ones that are firmly grounded in the facts that you're conveying to the audience. That is absolutely true of prosecutors and agents as well. Oh, okay. Um, and when you do this, when you convey this story, you have to do no harm. You just can't. I have a father who's a physician. I have a whole bunch of people in my family who are in the medical world, and this, my wife's midwife. All of them sort of adhere to this idea of medical world first do no harm. That is 100% true about defense lawyers and targets of investigations. You can't do anything, even when you're making that pitch, that harms your case. Can't talk too much, can't create inconsistencies. Strategically, you may have a great defense, but you're worried about revealing too much. If you think that you don't really know the terrain of the prosecutors you're dealing with, how they're going to accept information, giving them information may just cause them to, craft a lie around it. And you have momentum and you don't want to lose that. And so as you're preparing this sort of stage of, all right, I think I know what's going on. I have a good idea how we're going to be able to sort of create a strategy going forward. The first thing you have to hesitate and to do before you actually act is you have to say, is this going to harm my client? Or if I'm that client, is this step going to cause me to be in a worse position than I was without it? But once you've made that commitment and you've said, okay, this isn't going to hurt us, you've got to advocate like you're not coming back. The reason the last part of the title is stingers, spies, saints, and stingers, is sort of analogize trial lawyers a little bit to Muhammad Ali. You've got to float like a butterfly and sting like a bee. You're dancing around that courtroom, but when you punch, it has to be effective. Um, you only get, that first phone call with the government once. You may get a proffer. You don't generally get to rehearse it. And those first impressions matter. And if you hesitate, in that story, they ask you, okay, well, gosh, what about this really bad fact? I hear you saying your client's not innocent. I hear you saying this isn't a criminal act. I hear you saying things of that sort. But what about this problem? If you don't immediately knock it down, if you don't immediately hit them with something that makes them convinced early, um, you're doing yourself and your client real damage. To do that, though, it has to be earned conviction. Plenty of people will have conviction about an argument. There's plenty of defense lawyers, and I think we're probably the worst at it. Act with conviction or pretend to have conviction that, yes, we're going to win this because, I can think of examples right now of lawyers I've worked with who just think that bravado is enough, oh, I'm going to show conviction, my client's innocent. But if that bravado isn't based on a real sound understanding of the facts and an understanding of how you're going to move and motivate the juror or the judge or whoever to your side, it's completely worthless. Um, you have to know why you're punching, why the punch is going to work. But once you do, you've got to throw it really, really hard. And as I get sort of towards the end, I think it's critical to go back and say, if you skip a step, the structure collapses. If you're in the first 72 hours of a case and you just start saying, you should dismiss this case, prosecutor, case agent, leave us alone. You start advocating for end games and solutions, but you've done that without actually knowing what's going on, without the facts. That's reckless. It's swinging in the dark. And so many defense attorneys do it. I don't know how many times I hear of a situation where a defense attorney who gets a new case will call up the prosecutor immediately. Oh, I know him. He's a buddy. Hey, I represent so and so now. That you got no case. You should get out of here. Completely reckless, because if you know nothing, you've lost credibility, and you can't do the sorts of things that your client needs. God forbid, in that case, your client actually is innocent. You've got some really good exculpatory information. You can't use it because you've kind of just picked up the phone and the prosecutor realizes you're just bluster. At the same time, you can't diagnose without really empathizing about the government's position. If you don't know what they're doing and why they're doing it, again, you're creating a strategy that's completely made up without any sort of acceptance of who the judge is, who the prosecutors are, what the real terrain looks like that you're navigating in terms of other people. But if you just empathize and you spend all your time trying to game out, and I've got some clients who like to game out what the other side does a lot. Well, I think this prosecutor is doing this and he really cares about that. And that's why they're going to do this thing. You can spend hours, days, months doing that. And if you do that without actually getting to the advocate step, without actually saying, okay, and because of that, I'm going to do this and I'm going to punch my way towards a solution, then you're just experiencing paralysis and it's completely useless. You're going to see it all, but you're going to literally achieve nothing, which is not what you want to be doing. And so, if the knock comes, for those of you who have been there, I think you can imagine that it's really useful if you knew at the first moment what's the lawyer going to call. You're going to commit to silence and you're going to trust the sequence, because I think trusting the process is a really hard thing to convey to other people. And so if someone calls you up because they know you've dealt with the criminal justice system or you've had family that have done it, and they ask what to do, I think it's not just know that you need to call a lawyer and know who that lawyer is. It's not just commit to silence and sort of sitting in that discomfort of not being able to respond. It's also trusting the sequence, that knowing that if you've got a lawyer who's going to move you through this process of understanding the facts, of empathizing with the other side and understanding their position, and then crafting an advocacy message that's going to be direct, clear, one message that you're going to use and use aggressively from the start. If you find somebody who can do that and you trust the process, the chances you get a much better outcome based on your facts compared to what it could be is much, much higher. Um, so That's it. I appreciate, folks in this room, you already know the cost of what can happen when this goes wrong. Um, help the next folks do it right. You can reach me. Folks know how to find me. And I hope that we always hope that we get cases at the very beginning because it's a lot harder to undo damage months and years down the line. And then if you want to read more about this sort of whole concept, the book is available for pre-order on Amazon. You can go to s3book.com and it'll take you directly to Kindle. And you can also QR code that there. It comes out in August. And it talked about, these sort of concepts of um, diagnosing with discipline, using objective empathy, and then ultimately advocating kind of evangelically as if you're a courtroom preacher, and draw on some case studies, some of the things that we've experienced both in the courtroom, but also in Africa and other places around the world as a analyst and as a diplomat. So I appreciate you guys listening to me.
Alex, thank you so much. That was an incredible presentation. I'm sure there's a ton of questions. If anyone would like to ask Alex a question, please put your name in chat and I will call on you. I'm actually going to ask the first question, Alex.
Sure.
So I think that many, if not most of us, um, have known that there have been things that have gone wrong and we've been in denial for a long time, um, looking over our shoulders, not really understanding potentially what the impact is. Maybe we're over drinking, somehow accommodating us. So how do you get people like into the reality of the moment, and first talk to them about like there's an order of things that have to happen, and you have to get into this reality right now.
I think it's probably the most difficult thing about being an effective criminal defense attorney is learning how your individual client processes information. Because I think a lot of folks, particularly those who are jaded, who have done it for a long time or are just tired, they don't really care about that process. They just say, this is the way it is. Listen to me now. The situation you're in is X, Y, and Z. And I'm just going to tell you once that's the way it is. And they keep getting questions. They just say, nope, here's the answer. I'm just going to tell you the answer. And I think that does nothing for the client because what you're talking about is how do you get the client based on whatever denial or just sort of unwillingness to face reality that they're dealing with to actually open themselves up to those bad circumstances. That's really therapy, right? And oftentimes I feel like a therapist. So much of what we're doing is helping that client think about the blocks in the way they think, whether it's just, it's childhood traumas, the way they view the world, personal, just issues that makes it difficult for them to see things. And so a huge part of the balance in the early days of a lawyer and a client is establishing that rapport where you start to understand each other as people and you understand how this person hears and processes information and then do a great job of trying to communicate that. I think a lot of that I learned from my father was a pediatrician, so primary care physician, had to talk to parents and kids about the fact that they're sick. Well, kids generally can't tell you what's wrong if they're really young, right? And so watching him sort of communicate important information and try to get information out of people who literally can't communicate, I think taught me a good deal about that process. You have to be patient, and you have to, give the client a chance to get themselves thinking more clearly about the situation.
Um, Thank you, Alex. All right, we're going to open up the questions first, Stuart, and then Brent, and we could use some more names in chat, please.
Hold on 1 second. Having technical difficulties. All right, here we go. Alex, thank you. I really appreciated that. That was really excellently done. I'm way after the fact. I wish I'd have known you before, but here we are. Anyway, I really screwed up, but this is an interesting thing. I let them in my house. So I had the Postal Inspection Service come to my house, had no idea why they were there, but thought it was based on some escrow that I was doing. So I'm like, yeah, come on in. I started just chatting with them about it. They're asking me about what was going on. And it wasn't until later in the conversation that it started turning toward me. And that's when I went, wait, what? Are you're talking about me? And that's when they handed me a target letter.
Yep.
I had already talked to him because I didn't think I did anything. As a matter of fact, I was just trying to help. So sometimes, and I was an attorney, but I was a dumbass. I'm like, what am I thinking? Why would I allow them to come in my house? Now I wasn't thinking at it as a defense issue because I didn't think I was doing anything wrong to begin with, but I knew there were some issues with the escrow. You see what I'm saying?
Sure.
So given that and what you were saying before about, I had already given them some information, and I've already given them. And what did they get me on? Get me on was a willful blindness issue based on some of the things I had said to them. Like, yeah, I kind of saw there were some issues, but I wasn't sure, blah, blah. What a dumbass. So when I say this, then that's what they get me in a conspiracy for, even though willful blindness is not an actual code section, that's how they get you, that's how they tied me
Sure.
into conspiracy, right? Is there any, I don't know what I'm asking you, but I mean, in that type of situation, I think I was kind of screwed right from the front, wasn't I?
Well, I think it's important to, one of the things I don't talk about here is, but it's sort of part of that second piece of understanding the other
Yeah.
side, empathizing. You have to appreciate that those folks have their own goals, and one of their goals is to secure a conviction. And so from the moment they interact with you, they are using every tool in their disposal to build their case stronger and better, right? And they are purposefully using the human desire to be agreeable, to be seen as helpful, particularly when if you're someone with status, there's a sort of general agreeableness you want to have when federal law enforcement shows up. And so they are using the advantages they have, and it's perfectly rational for them to do that, right? And sometimes, if you're not prepared ahead of time to be aware or concerned about the fact that the government can just do that, you're really at a disadvantage, like you were in your situation. And so I think the only thing that helps that is just education. When people hear about these stories of cases like this, your family members, your friends, they're going to be less willing to let the postal inspector in the house. They're going to be less willing to just talk openly. I have so many clients, and one of my clients who's spoken really publicly about this is the Chrisley family who got pardoned, and Savannah, who's in her 20s. She's like, I have no idea. I've never been involved in criminal justice. I had no idea these things happened. And so the other side, they benefit from that lack of awareness and lack of knowledge, and they use that to build cases.
Absolutely.
Th-
Well, I appreciate you. Thank you.
Yeah,
Thank you,
absolutely.
Stuart. We're going to go to Brent, and then let's see. Anastasia has a question. All right, let's go to Brent.
I'm sure Alex, everybody on this call is thinking, wow, I wish I would have known Alex. But I've been lucky enough, Alex, to actually interview some people on my show that had you as an attorney, and they think so much of you and how you do what you do, and thank God you're there doing what you do. I'm curious, in so many different cases, especially when you get to the federal level of being charged,
Yep.
they can scare you to paralysis with stacking charges.
Sure.
They can take mail fraud, wire fraud, and then they can just stack those, and then you're looking at possibly hundreds of years. I'm curious, in your mind, when you sit down with a client and you know that they're scaring this person into paralysis, but you know that there's a case there.
Mm-hmm.
You know that if you could just get them, and I know some of the people that you've been and have been successful with, they had the courage to step through that. Do you, as an attorney, help them find that courage to see the possibility that the light at the end of the tunnel is not a it's not a train, it's actually an escape to get to freedom? Do you help them with that? How does that play
I
out
think
with?
it's a critically important part of what we do, because the other side is going to hit you with fear, which is an incredibly powerful motivating tool. It works on a lot of people in a lot of different ways. It is, one of the base sort of reptilian things that drives humans, right? Survival, fear. I can't uh, avoid this or that fate. I've got to deal with this. I think what I try to do in that situation as a first step is really, again, in that objective, like the discipline, to diagnose with discipline, you have to strip away bias, you have to strip away fear, and you have to sort of tell your client, we got to look coldly and calmly at what you're facing in the situation. I hear that you think there is an exit because you're so scared of this scary thing here that the exit's going to be a plea agreement to this or that. Let's talk about what that means. Because a lot of times fear is combined with false promises, right? Well, it's not going to be so bad. You're only going to get probation. Well, no, you get 8 years in jail. Or it's not so bad because, this isn't going to happen and that isn't going to happen. And when you start to sort of unravel the kind of false information that comes with fear, I think it allows people to sort of let the fear go a little bit. And so a huge part of dissipating the fear is being really, insistent on, let's actually talk about what the facts are. Here's what they have. Here's what they can prove. Here's what that means. And sometimes, I mean, if you're looking at a murder charge or other huge things, it can be seriously scary jail time. It also may mean your alternative is you want to do 20 years in jail or 30 years in jail. You can agree to do 20 or you can fight and try to prevent yourself from doing 30. And I think when you start to lay those out as more, this is just I'm not going to tell you what you should do, but I'm going to be really objective about the decisions before you, people start to weigh that a little bit better. I mean, we've had 2 cases we've lost at trial in the last year. And cases where, jury was out for numerous days. I think we could have won both. I think we have a good chance to win one on appeal. But the result after trial was a third to a sixth of what the government would have asked for in a plea. And so one case in particular we had in Nashville, the government wanted 15 years in a plea, and the guy got 3.5 years on a $26 million conspiracy. And part of our conversation was, look, there's a risk here, but let's talk about why your case isn't as crazy and there's some mitigating factors here. So even if you lose at trial, your situation isn't as bad and scary as the government's trying to push you into over here. I had a lawyer who, after that sentencing, said, how did you do that? He knew what the initial plea was. And I said, I think we were just really objective about what we could and couldn't do. We got some lucky breaks. The judge, I think did some good things for us. But oftentimes fear is based on lack of information.
Thank you, Brent. Anastasia put in the chat, how do you deal as an attorney with a prosecutor repeatedly lying during the trial? Alex, we've had people report recently, I think on one of your cases actually, that even on closing, they were mischaracterizing evidence, they were mischaracterizing testimony.
Yeah.
And then you're sitting there. What's the strategy that you employ or not?
So the strategy you don't employ is when you don't just say, oh, it's no big deal, or oh, the judge won't care, or if I say something, I'm not going to object because it might look bad. Attorneys who say that, I think, just shouldn't be in this business. When something like that happens, where it's blatantly improper, there's a blatant lie, the prosecutor is trying to do something they shouldn't do, you have to object loudly, vociferously, and repeatedly. You have to make the record. You have to call them out. If you can do an objection, if it's a closing statement, I'd stand up and I'd object, and I'd try to make a speaking objection until the court throws me in contempt. You have to match the sort of wrongdoing that's being done with equal advocacy, right? I heard of a case, we may be getting involved in a case in the Midwest where a prosecutor made up a fact in the rebuttal argument. So the defense has no opportunity then to do anything. It's a completely made up fact. Prosecutor knew was false. Misconstrued an exhibit on a real key motivation issue. And I wasn't there at trial. If I would have stood up in the middle of a rebuttal, made an objection, done it speaking. I don't care if the judge get mad about it later and say, Your Honor, that's not true. There's no evidence of that. He should be sanctioned. It's succinct, it's short, but it mitigates that damage. Mm-hmm. And so, I think the short answer is you have to be loud, and part of our job is to be objectionable, right? We don't need the prosecutors to like us, the judge to like us, and sometimes we have to take arrows for clients.
Mhm.
I remember one client kind of won for life because the judge wanted to throw him in jail for failing to appear at a hearing that we told him not to appear for because the clerk told us not to appear. And I said, Judge, if you're going to throw him in contempt, you need to throw me in contempt because I'm the one who told him he did it. You have to put yourself in between the client and the court. And I think sometimes defense lawyers don't do that.
Thank you, Alex. Gordon asked a question. How often
How
do you
often to
go
go
to
to trial?
trial?
Too often. My wife is on here. She could probably tell you way too often. We've done 2 trials in the last 6, 7 months. I've got 3 scheduled between now and December.
Um,
Mostly federal trials.
maybe the question is what percentage of your cases go to
Oh,
trial?
go to trial. I mean, that's sort of it depends on the case, right? I mean, we were about Ryan, who's on here. We were about to go to trial in his case, and the government did the right thing and dismissed on the eve of trial. I think every case is different as to whether you get a good resolution or not. We've worked out great plea deals. I often find that you work out much better plea deals when you're serious about putting on a defense and when you're able to articulate that defense to the government. It gets you much better deals. And I'm not here to tell a client what to do. The client thinks in their calculus taking a plea is a better option. I'm more than happy to get it done.
Thanks. Dylan asked a question. Do you assist with plea negotiations with someone's current counsel in the DOJ? I guess that question is, do you ever come in
Yes.
on a
Yeah.
consulting basis?
Yeah, we do it a lot. I mean, one of the things that I tell people, I had a conversation actually 10 minutes before this started. I think that good defense attorneys are generally always open to working with more good defense attorneys. I think the folks who are confident in what they do and are good at it love more attorneys in the room because I don't know every perspective. I'm not going to think of every idea, but I'm pretty good at making judgment calls
Mhm.
about them. So if there are more people throwing out ideas or I'm able to sort of lend an idea to somebody else, I love working with good lawyers and helping them see things maybe they didn't see and coming up with ideas. I think that if people are lucky enough to have the resources to be able to do that, what a privilege! Because I mean, there's a reason OJ had 7 lawyers, right, or 8 lawyers. If you can manage it and you can get along, it's a huge benefit.
And as Tom Hanks said, the 3 things an actor needs to know is show up on time, know the text, and have an idea.
Have an idea. I love that quote. Yep.
Scott, you have a question?
I do. I want to go back to the 72-hour mark because,
Yeah.
many of us will get hit with a knock at the door, out of the blue, whatever the case might be, and you have nowhere to turn. I mean, in my case, who am I going to turn to?
Yep.
This is a Texas case versus I'm in Florida. I reached out to a friend in God, out west. What do I do? Okay. Who in turns referred me. But I mean, you talk about the 72 hours, but for, there doesn't seem to be a network
No, there's
that
not.
to reach out to. Meaning,
So,
the first 72 hours are that critical. I went through an attorney that I really think was way too lightweight, okay, had no jurisdiction in Texas.
right.
Um, he'd have kissed anybody's bottom soul if he could just get 10 minutes with the prosecutor.
Yeah.
Um,
Well,
so go ahead.
I don't want to interrupt you, Scott, but this is something I think we've identified. I don't know how many of you know Amy Nelson. She is a colleague and a longtime friend. We worked at the Carter Center together. She does lots of advocacy work for justice impacted families. And she's always said that, you know, even she, who is a lawyer at a big firm, didn't really know who to call. Eventually, she called me pretty quickly. But we really think that there is this vacuum about information in the beginning. And so we are actually we're starting a podcast that focuses on that first 72 hours. It's kind of around this topic I talked about here, but we're also trying to find some resources on the web to give people for free where it's like, look, here's a list of what you need to be doing and not doing. Here is the link to folks who are either NACDL counsel or experienced lawyers. Here is a guide to how you hire a lawyer.
Well, and,
Every
and on that note, in all due respect, like with Jeff's group, or I also run an advocacy group on school, 500 members.
Yeah.
if I knew what I know today,
Oh,
I
for
wouldn't
sure.
have made the same mistakes I made 5, 6 years ago. Okay. I mean, I didn't consider myself guilty. Therefore, letting a sheriff and an FBI agent into my house to do a little one-on-one until they asked me for my computer. And I
Right.
did a push away. But I think those of us that run advocacy groups really need to get with proper representation, lawyers, lawyer groups, lawyer firms, because obviously I'm in Florida. So it doesn't do me any good to hire an attorney in Florida to represent me in a Houston courtroom. So I was in left field.
Right. And I think that the answer to that is more information, more broadly distributed. And that's one of the things that technology is helping us do. I mean, we are, in a world where you can kind of go to Chat GPT and say, hey, what should I do here? And one of the things we're working on is trying to help get answers that will be easily read and sort of processed by LLMs. So when people check those things in the future, they'll say, oh, before you hire an attorney, ask these questions, get these. I mean, I tell people, even when they're talking to me, you should talk to three attorneys. You should talk to three. You should ask them who they would hire. You should get a sense of what they would do. You would ask other people about them and then feel your comfort level with them. And nobody does that. They just get the one referral from the one person who knows, call this guy. And 80% of the time, that's who they hire. And it's usually just a disaster.
Thank you, Scott. Yeah, I think, Alex, one of the things that most of us have in common is that we'll just do or pay anything for the pain to stop. And
Oh, for sure.
we all know that the pain isn't stopping anytime soon.
No, and it's the disadvantage structurally of everything you're facing, for sure.
Ryan, then Lucky.
Hey, Alex, it's good to get to talk to you for free for once.
Ryan, I'm going to bill you. Don't worry. Hold on.
Oh my God.
That's a point one. That's a point one.
Exactly. So, obviously just so much respect for you and your firm and the role that you have played in my life. But a question I had for you, and you kind of started to touch on it earlier that I think is really huge is um I was aware of the trial penalty and only the trial penalty until I actually got a consultation from a different, very, an attorney I respect a lot. But he told me about the trial benefit and about how going to trial can give the judge a greater appreciation. And then, you had three clients go to trial with a combined, 40 plus years of sentencing exposure, and one of them you got the case dismissed and never would have if you weren't ready to go to trial. Another one got 2 years, another one got 4 years, and those were all, those other two were convictions at jury trial.
Right.
And so I'm just curious, like, how do you get the word out? How do you evangelize, if you will? Like, there's there's a huge just belief in the space that the trial penalty is just automatic.
Yeah.
How do you sort of how do you sort of get flip that and kind of get that out there that you can literally lose a trial and still have a better sentencing outcome?
I think there's a couple ways I'm going to answer that. First, I'm going to sort of promote the book a little bit. Part of what that process of doing some real factual investigation and thinking about the objective empathy is you think about how the judge is going to view the facts. How is the judge going to see this case? And you all know, because you're doing this group and you talk to these people, that white collar criminals in particular are not bad people generally. They often are people who have the government's convinced has done something on a judgment call that is pretty reasonable or at least justifiable. And there's these shades of gray. And so when you have a case like that where there's shades of gray, explaining that gray in detail and pushing against the government's real harsh black and white view of what's happened generally is going to get you benefits. When you plead guilty in a white collar case, you only get the government's version of the facts. And you and your lawyers are often just very afraid of fighting those facts. When you get a trial, the judge hears all of it. And sometimes they're not convinced. They may think, gosh, the jury got it wrong. I can take care of that at sentencing. So I wouldn't say, for example, in a sex crime case or in a violent murder case that there is often a benefit to that, right? So the trial benefit is much more common in cases like the ones that we've been talking about here, where it's good people who are in situations that are ambiguous, and you've got prosecutors who have decided it's black and white.
Thank you, Alex, and thank you, Ryan. Next is Lucky, and then Jim. And all right, Lucky, go ahead.
Hey, thanks a lot, Alex. Great to meet you and have you here. I
Absolutely.
experienced a pretty aggressive, misguided prosecution out of the Southern District of Georgia and had Stephen Lee as my attorney. Thank God I ended up with
Great
him.
attorney.
Yeah, man. Yeah. Much to what you have spoke about today. I was just curious, are you seeing a lot of, I don't know, it seems to me like just a lot of lack of integrity or an honesty, or is it these prosecutors just get a narrative in their head and they're just misguided? I tried to cooperate with the government and did like 2 proffers, and I was not parroting what they wanted to hear, and fortunately was able to win at trial. And one of the numbers Stephen throws out too is that the government's win rate at trial with these white collar cases is really only about 85% or so.
Right.
And also to your point, going to trial allows the judge to hear all the facts as opposed to a plea. But anyway, are you seeing anything in the space that it's just maybe a little lack of integrity, or?
Let me ask this: what was the agency that investigated? Was it HHS?
Yeah, all of them. It was pharmacy, anti-kickback. So I had Secret Service, HHS, DOJ. Yeah, it was everything.
One of the things that I think is an example I bring up. I was a prosecutor in Washington, D.C. There were 140 or 160 different police department or law enforcement agencies in Washington, D.C. And I kind of learned this reality that as you go down the line with law enforcement agencies, the talent pool is very different. I mean, I remember a case I had with the Food and Drug Administration, which has its own criminal investigation service. It was probably the most unethical, corrupt agent I'd ever seen. And it kind of made sense that he was at the FDA because he probably applied for the FBI and didn't get that job. He probably applied for ATF, didn't get that job. Probably applied for Secret Service, didn't get that job. Couldn't work for the DEA, couldn't work for Postal, couldn't work for HH. And so you just, at some point you have just a human capital problem, right? If morals are on the same sort of bell curve as everything else, the distribution is going to be probably different. Doesn't mean the FBI doesn't have dirty agents, they do. But you see the same thing, I will say, with U.S. attorneys' offices. The type of mistakes and aggression that comes from SDNY is generally driven by true believers and strivers that are striving for a big career, making a name themselves, putting a feather in their cap. That's not what you get in Savannah or other folks in Southern Georgia, right? You get folks who've been there forever, have no oversight, have been able to do whatever they want to do without any pushback, have a local bar that generally would much rather kiss their ass than make them respond to emotion or, God forbid, try to sanction them. And so what I would say just on the sector is smaller offices with less oversight, with prosecutors who are more time full-timers, generally are going to be more problematic than big city, big office turnover where you've got supervisors who may move up by merit. I don't know what that's going to look like in this administration as it goes on. They've lost a ton of people. I mean, the offices are getting gutted. None of that is good for justice and for our clients. But I would say my response to that is it depends a lot on who's investigating you and where you're being investigated. And if you just think of it as a human capital question, that explains a lot of what we're seeing.
Thank you, Lucky. All right, two more, Jim, and then Val put a question in chat.
Sure.
Thank you, Jeff. Alex, thank you for your presentation. And
absolutely, thanks for having me.
Yeah, for sure. I was just in Nashville over the weekend, in fact, and thought about you because I knew this was going to be happening. So my question has to do with you have participated probably in situations where your client was a victim of a sting. And perhaps you've been involved in a case that was a reverse sting, where the government sets up the entire operation and they do things. I can use a lot of words, but I'll refrain from those words. So why do they do that? There's like billions of dollars of Medicare fraud all over the place. There's billions of other fraud, and now there's huge fraud in certain states, but they've got to go out and create crime. Why? I just am curious
So
on your thoughts.
I sort of now point you to the second section of the book, the sort of objective empathy. You got to think about why these agents do what they do. Um, I remember there was I'll go back to an FDA agent. He had to do some inspections from time to time, but man, all he wanted was like one big good case, right? Because generally, if you are law enforcement, you see yourself as the hero. You're saving, the community. You're the first responder. You're sort of this strong guy or girl who's out there fighting crime. And that isn't really the reality of many of these offices. You're doing paper, you're doing subpoenas, you're going through documents. And so sometimes they just want action, right? Gosh, they get a lead that there might be some issue. Let's set up a sting. We're going to catch ourselves. I mean, this happened a lot around the Muslim community. They were targeting for kind of trying to find ISIS folks, right? And they'd be like, hey, do you want a rocket launcher to go shoot at the local FBI? They'd create the problem they thought existed because it fit the narrative of what they were supposed to be doing in law enforcement. And I think, again, if you look at it from the perspective of the agent who's doing their work, not all of them are that way, but there is this sort of, thread of, I'm supposed to be doing counterterrorism work. There should be counterterrorism cases. Where are they? If I can't find them, they must be there somewhere. So I'm going to go ferret them out by doing a reverse sting.
Thank you, Jim.
Jeff, could I just do a follow-up?
Sure.
So one additional, Alex. And sentencing, I have two situations I'm very aware of, and the same amount of money allegedly got taken. One person got a 10-year sentence and the other person got a 4-year sentence. And I've seen a lot of discrepancies in sentencing. I'm just curious on your thoughts on that, why it's not maybe more consistent with specific parameters that fit to determine what it would be.
Well, look, that's what Justice Breyer wanted when he helped write the sentencing guidelines, right? He wanted these very small boxes where there would be uniformity. I think that system has a lot of problems. So now we're stuck with the opposite world where you're going to have disparities. And I think it is a cruel, harsh reality. But the best way to protect against disparities is just get the best advocate you can, know the situation, and protect yourself. You can't, if you're in the system, you can't focus on the fact that there are disparities. You've got to see, again, that sort of first step of real diagnostic discipline. Is my judge somebody who gives harsh sentences? If they are, what moves them? Look at the history of what they've done. Am I just in a really bad spot? Article 3 lifetime judges, you're going to get some who are terrible. And if you draw that lucky stick, it's sort of like, I compare it sometimes to cancer. There are different types of cancer. Some are, you could both have lung cancer. One responds to treatment, one doesn't. Turns out one's genetically predisposed not to. That's kind of what it's like. Same exact bank fraud, same exact amount, two different courtrooms. One person's in jail for a year and a half. One person's in jail for a decade. You got the bad strain, right? I think if you're looking at it objectively and coldly and coolly, that happens and it sucks, but it happens.
So Jim, I think there's another way to answer the question that's consistent with the theme of what Alex has been talking about. The person who got the 4-year sentence is not going to complain about the guy who got the 10-year sentence. It's the guy who got the 10-year sentence is going to complain about the guy who got the 4-year sentence. So
Correct.
I think what we've learned here today is that the process starts on day one, and you want to be the guy with the 4-year sentence.
Yep.
There's a lot of other questions in chat, but they seem to be getting into the weeds. So with your permission, Alex, if you'll give out your contact information,
for sure.
We'll ask people to get in touch with you directly if they have specific questions.
It's right there in the chat, Alex at litson.co, not .com. That's just to make it difficult for everybody and make sure you were listening. Um, and if you want to check out the book, it's S3, the letter S, the number 3 book.com.
Um,
And I appreciate you guys having me.
Alex, thank you. Really wonderful evening. I can't think of anyone who's ever been more generous to us with their time and their experiences. Thank you so much for that. Thank you, everybody. Remember, White Collar Support Group meetings on Monday nights at 7 p.m. Eastern. More information is on our website, prisonist.org. That's prisonist like feminist.org. Thank you all, and we'll see you again next time. Thank you. Bye, everybody.
Thank you all. Take care.